Good afternoon. All right, we are on the record in the matter of People versus Latavis, Trashad, Thornton. This is case 25-0203FY and may have appearances for the record, please.
George and on behalf of the people, Your Honor.
Thank you. And
I'm Melissa Vachon with the Office of the Public Defender, Your Honor. I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
okay, and Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavis Trashad Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir.
Mr. A?
Mr. Thornton. So if you want to appeal, you
Please,
want.
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavis Trashad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But
Yes,
there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton.
Before we even hear the first ruling, you already know exactly where this is going, because this is the classic sovereign citizen playbook unfolding in real time. A defendant walks into court convinced that words alone can override reality, that labels beat law, and that if he talks long enough, confidently enough, the rules will somehow bend around him. But here's the twist. This judge isn't confused, intimidated, or impressed. She's calm, methodical, and absolutely prepared to dismantle every pseudo-legal argument piece by piece. What makes this case fascinating isn't just the nonsense coming from the defendant. It's how professionally and surgically the court shuts it down while still protecting his rights. Pay close attention to how patience slowly gives way to firm control, how legal fantasy collides with courtroom procedure, and how the defendant's own words quietly undermine the image he's trying so hard to project. And here's the big question for you watching. At what point does confidence cross the line into self-sabotage? Because this case answers that in real time.
So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail, okay? So,
Can I please?
because here's the thing. I don't want to be disrespectful to you.
Right,
And
absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm
Okay,
fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know?
Anyone familiar with courtroom dynamics? The moment a defendant refuses to acknowledge their own legal identity and replaces it with an organization, a title, or a philosophical concept, the court immediately has to slow things down. Not because the argument has merit, but because the court must ensure competency in due process. You'll notice the judge doesn't mock him or dismiss him outright. Instead, she references prior competency concerns, past failures to appear, and unresolved sentencing issues. That's not accidental. That's the court quietly signaling, we've been here before. And it raises a serious question. Is this a calculated tactic to delay proceedings? Or does the defendant genuinely believe these concepts shield him from jurisdiction? Either way, the court's responsibility is the same. Protect the integrity of the process while safeguarding the defendant's rights, even when the defendant actively resists doing so.
And
Okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for Latavius Treshawn Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this and then I'll acknowledge you in just a minute. You haven't seen the evidence.
Okay.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay? You can't really defend yourself unless you know what you're.
Courtroom reality slams directly into internet myth. Arraignments are not debates. They're not trials. They're not platforms for speeches. They exist for one purpose: to inform a defendant of the charges and protect constitutional rights. The judge explains this patiently, even humorously, offering to call him defendant instead if that makes things easier. But the underlying message is crystal clear. Identity disputes don't stop jurisdiction, and refusing a name doesn't pause the case. What's interesting here is how the judge balances authority with respect. She's not flexing power, she's explaining procedure. Yet the defendant interprets structure as disrespect. That misunderstanding fuels everything that follows. And it's worth asking, how many defendants lose ground not because of evidence, but because they refuse to understand where they actually are?
Accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor, and that is why I feel it necessary for me to make certain things known for Latavius Treshaw Thornton, for that the script can, so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders.
Change perfectly highlights one of the most misunderstood aspects of courtrooms. Silence is protection, not punishment. When a judge limits a defendant's speech during arraignment, it's not censorship, it's legal safety. The judge is actively preventing self-incrimination, something defendants often claim courts never do. Ironically, the more this defendant insists on speaking freely, the more he risks damaging his own position. Courts are not open mics. They are structured environments governed by rules designed to ensure fairness. And when someone insists on treating court like a philosophical forum, it creates friction that only works against them. The judge's explanation here is textbook, calm, logical, and legally sound. The tragedy is that the defendant hears control where there is actually protection.
Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that. I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry. And
okay. All right.
Yes,
so
ma'am. Your Honor.
Here's the thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago. And he said, and he really upset people with this, he said, corporations are people, my friend. And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law. But a person does not become an LLC. But regardless, we're going to read these charges because you have a right to know them. So in count one, you are accused of police officer assaulting, resisting, and obstructing, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count two, you are accused of assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now, we're going to talk about your rights. You have the right to an attorney, and today, Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. That said, you can hire any attorney you wish. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence, and you could question any witnesses the prosecutor called. You could call your own witnesses. And if they didn't want to appear, the court could issue a subpoena and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you could bring any evidence you wished, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, and you know this one, this is your Fifth Amendment to the Constitution, you have a right against self-incrimination. And that means no one can do anything that forces you or tricks you into making yourself guilty. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. Here's what I'm gonna enter. I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first? Before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
The most important moments in the entire hearing, and many viewers miss it. The judge clearly explains the difference between until and unless, reinforcing the presumption of innocence in a way that's both legally precise and human. This isn't hostility. This is education. The court is going out of its way to ensure the defendant understands that nothing has been decided, that no conclusions have been drawn, and that the process is still open. Yet instead of absorbing that reassurance, the defendant continues framing himself as misunderstood and threatened. That disconnect matters. Courts can protect rights, but they can't force someone to accept reality. And when someone refuses to do that, every interaction becomes adversarial, even when the court is extending fairness.
Nope. So a plea would have you pleading, would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it. And I think that's what you want to do, because that is your hard-fought constitutional right, among other things.
It's a bit more to it, Your Honor. That's the issue. So based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting
Sir,
my life.
I know you don't want my representation, but I would advise.
No, ma'am.
I would advise that you not talk about anything that happened.
Please don't, ma'am. I appreciate that.
Okay.
I'm aware of why you're doing that, but I'm aware, like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. Once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am shoulders. Latavius Trayshawn, not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from this, all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Okay, so we have a couple different options here. First, the court is going to enter a not guilty plea on your behalf, so you can pursue that at a hearing where we can bring in evidence and that sort of thing, okay? Secondly, you have other options. You can also, you could investigate a civil suit against the City of East Lansing Police Department. There's a police oversight commission. So those are still available to you. Right now, I'm going to enter a not guilty plea so you can get the evidence to proceed. All right. Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, we're done. Okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
All right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30 March 21st, and a preliminary exam. You're going to get this in writing too at 9 a.m. March 27th. Now, my best advice would be to speak with Attorney Vachon because she can explain how you pursue those things. Now, we're going to move on for a moment to bond.
Kind of broke up at the end. I didn't hear what you said. I'm sorry.
Okay. We're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?